Good afternoon, everybody. Welcome to ICN members and their guests. I understand there's more than 230 of us communing today. To those of you who've never previously heard my name, I'm chair of the RTPI Independent Consultants Network, and I'm supported by a steering group of like-minded professionals. This is our first webinar, and it's been arranged as a modest replacement for our extremely popular annual conference. We have every intention that full service will resume next year so that we can once again meet and enjoy all the valuable and fun one-to-one contacts. In the meantime, can I urge any of you listening who are not already members of our web and email-based system to contact Jenny Devine at the RTPI and become really active. We share and support each other with experience, problems and learning every day of the year, helping combat isolation and enriching our business and professional skills. We also make good friends along the way, and those who join rarely leave. Our speaker today is Barrister Stephanie Hall from King's Chambers, who many will know has extensive experience in all areas of planning work, acting for a wide variety of developers and local planning authorities. She is ranked as one of the top planning barristers under 35. Lucky you, Stephanie. with legal 500
under 35.
with legal 500 describing her as a superb barrister. I'm very grateful she's given her time today to speak to us on topics which I believe will directly assist us with our work. Stephanie will be speaking to us for about 45 minutes, leaving time to answer a few questions from the audience at the end. Those of you have a look around your screen and you will find a question or a question mark button at the bottom of your screen if you want to submit something, and I'll do my best to squeeze as many as possible into the final part of the session, and they'll all come as a complete surprise to you, Stephanie. So we look forward to hearing that. Can I now invite you to take, finally, sorry, the presentation that Stephanie is going to give and a recording of this webinar will be available in the ICN webpage in a couple of days. So you can catch up, you don't have to write everything down, just focus, listen and enjoy. Stephanie, can I hand over to you and ask you to give us the benefit of your knowledge? Thank you.
Yes, well, I'll try. Okay, so the first hurdle that I have to surmount is sharing my screen and presentation with you. So I'm hopeful that I have managed to do this and that everybody can now see my screen. I'd be grateful for an indication from Jenny or Deirdre whether I've failed in my first task and therefore people can't see my screen.
I can see your screen.
And I'm grateful. Thank you very much. Great. Okay, first hurdle successfully surmounted. So hopefully everybody can see the title slide, which is Current Issues in Planning Law, Classy and Other Updates. If that title doesn't scintillate you, then I'm afraid I think you've got yourselves to blame, because that was what I was told the Independent Consultants Network wanted to hear about. So that is what you're getting. So we're going to spend some time looking at, I split it into four things: classy and the use classes order in terms of an outline. Then the real meat, I think, the issues arising out of those changes. I've tried to pull out a couple of the main issues that clients have been approaching me about, and we can well, I was going to say discuss those, because in a real world seminar, that is exactly what we'd be doing. But I'm afraid it's more of me talking about them, and then you'll have a chance to cross-examine me later through the Q&A session. And then issue 3: will the changes survive? They're being challenged at the moment, so we'll have a quick discussion about that. And if they don't, what's going to happen to us all then? And then item 4 is a quick case law update. I haven't sought to be comprehensive in that. I think by that point we'll be nearing the end of our time. So it's really a canter through what seemed to me to be three of the most important decisions spread across a variety of planning issues coming out of the higher courts in the last kind of couple of last few months leading up to today's date. So that's the overview, and without further ado, we'll get on to the Class E and the Use Classes order. Now, before we get into the changes that have been made by the 2020 amendment regulations, I think it's probably worth just spending 2 minutes going back to basics, because I think quite a lot of the questions that I've been asked and problems that planning authorities seem to be having with interpreting and applying these regulations stem from really a misunderstanding of the basics, which is just how the Use Classes order operates and what it is. So at its core, what it isn't is permitted development. What it is a list of things that are not development at all. So it stems from section 55 to F of the Town and Country Planning Act, which tells us a list of changes which are not development. And so permission doesn't get involved at all. It's not the GPDO where permission is required but granted through operation of an order. It's not development. Permission is a concept we don't need. It does tie in with the GPDO only where the GPDO also grants lists of changes that are development, yes, but also permitted by that order. So there are some changes which require permission, but are granted it by the GPDO. Also, the Use Classes order is incredibly relevant to us in defining permitted uses, either through setting out a description of development that we're seeking in a planning application, or by constraining changes that are not permitted through conditions. So, for example, the classic, you have permission for a retail outlet, and any food and drink you sell must be ancillary or must be, so you have these things constrained, and rather than saying, oh, it's retail, you might do it by reference to Class A1, or you would have done prior to September the 1st. So it's also relevant. The Use Classes order is a helpful framework for telling planning authorities things that aren't really material, so changes that are just fine. And so enforcement action should therefore not really be taken or wouldn't be expedient, because if you can define it as something that's approximate to something in the Use Classes order, that can be helpful, even if your use isn't listed. So the Use Classes order has all kinds of applications, but what it isn't to do with is permission. That's a concept we can jettison. I thought that was just helpful to set out at the outset. The amendments then to the Use Classes order and their impact, they affect all of those things. So they affect both parts of a planning permission that you might already have, or that you might seek in the future. They affect how you might set out a description of development in a planning application that you are making or have made. And they affect how you would deal with the local authority on conditions that might be appropriate. Conditions that the local authority might previously have sought to impose on your permission may no longer be appropriate. So, and we'll see later, this has obviously raises questions about, well, what do you do if I've already got a very unhelpful condition? How does that bite? We'll discuss all of that. But as you can see, that the changes are going to be relevant for both parts of a permission, the operative part and the restrictive part in terms of the conditions. They're going to be important for extant consents and future permissions that you might be seeking. They're going to be important for enforcement of changes that have already occurred. Is your client going to be at risk of enforcement now when previously they weren't, or vice versa? And also relevant in terms of what GPDO further changes you might be able to be entitled to or not. So just leaving that at the as an outline, turning then just to what I've actually said on the slide. So from September the 1st, that's the magic date for new applications, i.e. ones you hadn't got in before that. what the new changes do is they revoke Class A completely, they revoke Class D completely, and they modify Class B. So already, bells are tinkling about whether, well, what if I've got a permission that previously that refers to Class A1? If that's just completely revoked, what's the significance of that? We will come on to that in the issues section. So I just want to flag these now. And Class B is modified. So essentially what happens is bits of old B1 end up in Class E and bits don't. We've also got 3 new use classes: Class E, Class F1 and Class F2. And I'll just run through quickly in the next couple of slides what those new classes contain. So Class E, and it's worth just pausing on that. So what's the purpose of it? What were they seeking to achieve with Class E? And I think it's important, and it's something that I've heard Victoria Hills referred to in terms of who it presented this to Parliament. And it was somebody from the economic business side of the government. It was not a planning point. It was not about land use. It was not about appropriate neighbouring land uses. It was about helping the economy. That's where this comes from. So the driver is economic assistance to the town centre and to our high streets, and flexibility above all else as a mechanism for achieving that economic assistance. So that's where it's coming from. And obviously the repercussions of that, of prioritising that, which of course is a laudable aim, that you prioritise economic help over potentially the impacts of allowing that flexibility. So previously, if you were changing, for example, from things that are in Class E now, like creches and those kind of other uses that aren't retail, if you're changing from those kind of uses that don't have a very big servicing impact, for example, to A1 food retail, to a Sainsbury's or Tesco local or equivalent, they have a very particular impact in terms of servicing. In particular, they require tobacco to be delivered at a certain time. They require newspapers to be delivered before X o'clock in the morning, ditto bread, and all of these things would previously have been considered as part of whether the site's appropriate to be put into that use, and they won't be now. But that's the price of flexibility. So just that's the background to Class E. So Class E, as it says on the bullet points on that slide, it includes uses previously in Class A1, A2, A3, and some that were previously in Class D, so indoor sport facilities, creches, etc. Not all of Class D, but some of Class D. And as I mentioned previously, we've also got previous B1C uses. So those are the ones that are, yes, industrial processes, but are okay in a residential area, not producing noxious fumes, gases, etc., etc. What's interesting are the things that aren't in Class E and are bumped off into being sui generis. So I've got a slide on the sui generis uses later, but essentially that category has got broader, and there are some uses which would have previously been well, A4 and A5 uses in particular benefited from being in a use class and are now expressly sui generis. So there's obviously a desire to hive off pubs and hot food takeaways, and just having a stab at why, it's likely that the A4 drinking establishments is part of the government's desire to protect pubs. And we're seeing, even at the local level, lots of local authorities now adopting safeguarding public house type policies. Assets of community value also becoming quite relevant in terms of protecting public houses. And on the flip side, A5 being included in sui generis, that is part of the opposite intention, isn't it, to not have an easy switch from, say, a cafe to hot food takeaways, because they're seen as of generating odours and noise with extraction ducts and things like that that aren't welcome often in where there's flats above and things like that. And the government has said, well, they require more intensive consideration of their impacts, which is probably fair enough. So moving on to the F classes. So the F1 is learning and non-residential. So essentially that is the remaining uses from what was class D1, including education, museums, exhibition halls, places of worship, etc. There's nothing particularly exciting about class F1. It's more interesting, I think, to look at class F2, which is a new type of class and local community uses. And we'll come on to have a look in more detail about what any of that means in the issues section. But essentially, some of the types of uses that are included in F2 are an essential community shop, query essential, query community, community meeting places, outdoor sport, and indoor pools. So there are some questions there. I mean, what's particularly, I think, going to, and has already in my practice, caused people to be asking some questions is the community shop point. You know, when does your local co-op become a community shop, and when is it a classy old A1 just generic shop? And there is some help for that within the regulations themselves, but not a great deal. And we'll I've got a slide on that later because it is one of the issues that's come up. As I flagged up earlier, there are some previous uses that are within class, that were within a use class, but are now sui generis. And that defined list of things that don't have a use class and therefore require planning permission to change either way. That list has got longer. We've now got cinemas and concert halls, and these are some of the D1 uses, or some of the D class uses that used to benefit from being in that class. And we've already covered hot food takeaways and pubs. I think, again, it's a split, isn't it, between things like cinemas and things that might want to be protected, cinemas, theatres, etc., as opposed to things like dance halls, which might be more controversial and might fall at the hot food takeaway end of the spectrum in terms of their desirability to be in residential areas, depending. Particularly, I mean, like dance halls very much case to case, but it seems to be one of those things that the government has just decided needs a bit more of a careful look at. So right, the real now we've done the canter through what the changes actually are. What about the substance of this? How is this going to affect our clients? Well, first issue, when does it start? Well, it started on the 1st of September 2020, and how the structure of the use class order amendment regs work is by defining a quote material period, and in that material period, which is the 1st of September 2020 to the 31st of July 2021, you've got some transitional provisions, but the main point is the 1st of September 2020. Basically, if you had your application in before that date and you made reference to the old use classes, so you made reference to something that no longer exists, so you were applying, for example, to change an A1 retail unit to an A3 cafe or restaurant, and you got that in before the 1st of September 2020, and you'd expressly referred to those old, now no longer in force use classes. Well, Article 4 of the order would tell you that the planning authority is required to determine your application, quote, by reference to those use classes, which I think is some interesting wording. Note that obviously that Article 4 could well have said that the planning authority was required to determine your application in line with those use classes, or as if the regulations hadn't come into effect. There are plenty of transitional provisions that carry on expressly the effect of the previous order prior to the amendments coming in on a particular date for applications that are already in the system. This isn't one of those. The wording is different. The wording is more ambiguous, I'm afraid. It is by reference to. So there's some work for lawyers, I think, in there, unfortunately, not in line with or in accordance with, or as if this amendment hadn't taken effect, but just the application to be determined by reference to. I think that's probably a pragmatic approach. There's no point, is there, determining an application negatively that would now not be development at all. So in our A1 to A3 example, provided you don't have a restrictive condition that says thou shalt not have a cafe here, you wouldn't need that planning application anymore because you wouldn't need permission. So it's no point requiring the planning authority to determine your application in the system as if the changes hadn't come into force, because they'd be refusing planning permission for something that you don't need planning permission for. So I think the wording is a product of trying to just judge that balance between, obviously you've got to take it into account. The government has given an incredibly clear direction as to things that it thinks now are completely acceptable, so acceptable that they don't require any consenting regime at all. So obviously that is relevant to how they might deal with an extant planning application. Next bullet point then, what about previously consented schemes where the use classes are referred to in the description of development? Now the next two, the two bullet points, the last two bullet points on that slide, what I have done is divvied up description of development and conditions because we need to treat them separately. Basically, if you've got a planning permission where the use classes order was referred to in the description, and assuming you don't have use classes referred to in the conditions, or at least those conditions are not restrictive of a change of use that would otherwise be okay. What you need to be aware of is, if it's in the description, is if you wanted to change a condition and you would thereby be changing the description, or you would, if you got rid of your restrictive condition, you would fall foul, you would run into conflict with your description of development. We'll see later when we come to the case law update that that's going to cause you some problems. So basically, where you've got a condition that says this is restrictive of use class order changes, and that's echoed in the description of development, that's going to cause some problems for clients. But absent a condition, if it's just here we are granting permission for an A1 retail unit, then there's no reason at all why you should be restricted to A1. That is not a restriction unless it's echoed in a condition, and therefore not a barrier to you accessing the new rights essentially granted by the amended regulations. So happy days if all you've got is a reference to a use class in a description and it's not in a condition. Bullet point 3, however, well, what if I've got a condition? The first thing, I mean, this is where it gets a little bit tricky, is obviously it depends on the effectiveness of that condition at achieving its aim. So there are plenty of conditions that I'm asked to advise on even prior to these amendments coming in terms of the use classes order, as to, well, my client has this planning permission, does it really restrict use classes changes away from what it is? So the classic is, A1 no food, the classic is retail not cafe, or things like that, or the DIY stores, things like that, where they're trying to kind of pigeonhole you into a particular type of retail or a particular type of use. So I've recently had a shopping centre site where the permission tried to restrict a particular percentage of the uses to stay within A1 and not change to anything else. And so the question is always, well, was that condition any good at its job before the use classes order got involved? You know, was it restricting anything anyway? And then if it isn't, whether the use classes order buys you the use classes order amendment buy you an extra change. So if it is a true barrier, however, that's likely to persist. So if it was effective before, to exclude completely the operation of the use classes order, and if it did that effectively before, you know, this is just an amendment to the use classes order. So if you couldn't benefit from the use classes order at all before, there's no magic really now. I'm sure there will be some conditions that don't fit this rule, but broadly, if it was a really big problem before in terms of excluding entirely the operation of the use classes order, it is likely to continue to be a problem for you. Everything else is worth looking at the wording very, very carefully just to see what effect that truly has, that condition. Can I change the use then? Only if the use is already commenced. What about unimplemented consents, which refer to previous use classes? This is a question that comes up or has come up in my practice because of Article 7 in the amendment regulation. So if anybody's been diligent enough to go and turn up the actual regulations, you will see that Regulation 7 says, well, if a building or other land is situated in England and is being used for the purpose of one of the following classes on the 31st of August 2020, then that building or other land is to be treated on or after the 1st of September as if it is being used for a purpose in Class E. So, and that only applies to Class A1, A2, A3 and B1. So notably, A, it omits D class uses. It also provides a read across expressly only for buildings or land in use on the 31st of August, still being used as on the 1st of September. They're treated automatically as if they should be read across to Class E. So there's no automatic read across in Article 7 for Class D uses, even though, even if your Class D use finds a home in Class E, Article 7 doesn't get you there. So this has raised some questions with my clients, really, as to, well, obviously Article 7 gives me a gateway into Class E if my land is already being used and if it's not a Class D use. But what about the two scenarios where Article 7 doesn't get me home, it doesn't get me into Class E? What about unimplemented consents? And what about D class uses? Well, I think you've got some room for legitimate debate, but ultimately, you know, if you don't have an implemented consent, but you've got a planning permission that allows you a change of use to something that would be in Class E, you know, for example, if I have a planning permission that allows me to build an A1 retail shop, I don't have a restrictive condition, can I just go ahead and build a cafe? I think the planning authority are going to try and tell you you can't, because they probably don't want you to do that. And you end up in this ridiculous academic merry-go-round as, okay, but if I built it as a shop, I could just change it to a cafe the day after. Do I really need to build the shop? So I think arguably you can just go straight to the cafe, but there's no case law on that. And I think probably, you know, there may be some pushback from the planning authorities, but ultimately, I think the right interpretation of the regulations as a whole is that Article 7 isn't the only gateway. It gives you an express sort of highway, if you like. It gives you a bypass if you're, you know, puts it absolutely beyond doubt. If you fall in Reg 7, so you were already being used as something in Class A, you can switch to, you know, if you're already in use as a shop, you can be treated as being Class E as of the 1st of September. All it all it's saying is that it doesn't deal with the other mechanisms. That doesn't mean there aren't any other mechanisms of falling in Class E. I don't think that can be the case at all, or the whole thing wouldn't work. So whilst I'm saying there's room for debate, I think you can confidently push back and say, well, come on, it's not only implemented consents, is it? It's everything. Ditto D-class uses, although that has been remedied, sort of remedied, by a comment in the planning practice guidance, which says, I mean, essentially it says, oh yes, when we said A1, A2 and A3, we also meant the relevant parts of D1. That isn't what Regulation 7 says. But obviously, this is a kind of admission that the regs aren't perfect, and also they don't deal with every scenario, nor is it correct to say that unless you can crowbar yourself into Article 7, that Regulation 7, that you know you can't get into Class E. That's, I don't think, right at all. And the last bullet point I've got on issues is coming back to a different use class as F2. So I said I would come back to a community shop, and here we are. So regulation, so we're not dealing with Regulation 7, we're dealing with the new class F2A, which is a shop mostly selling essential goods. So we've got a query already about what on earth mostly means. Selling essential goods, so no definition of essential, including food, so not necessarily limited to food, just including food, to visiting members of the public in circumstances where the shop's premises cover an area of not more than 280 meters square, so it's quite a small unit, and 2, there's no other facility within a 1,000-meter radius. So that what they're trying to do is protect facilities where they are the only facilities. So actually the village that I live in, the shop would benefit from that, and I'm very grateful because I very much like having a shop 200 yards up the road rather than having to get in my car and drive somewhere else. But what's going to be interesting is obviously shops will either want to or not want to fall into this depending on what they're asking to do. But when I would have thought it would be more useful to you as a landowner or advising the owners or operators of shops that actually you probably don't want to be a community shop because it pigeonholes you into Class F2, and the better place to be is Class E. So if you can not be a community shop, that's probably more helpful to you, unless you are trying to get into Class F2 because you want to be a swimming pool. I think that's probably much less use to anybody. But we're not given very much guidance in the PPG for what is a community shop, and the quote that I've given in italics at the bottom of that page is, whether a shop falls in that class is going to be based on an assessment of the facts of the case at the time the determination is made. Well, thanks very much, PPG. That's made it all clear, hasn't it? But like I said, probably it's one to try and steer clear of if you want to have the benefit of the much more flexible Class A. So final point on the use classes order before we move on to case law update. Is there any point to the last 25 minutes of your life listening to me talk about the use class order changes? Are we even going to have them survive? I don't know whether people are generally aware, but there's a judicial review afoot at the moment, brought by an organisation called Rights Community Action. They are a collective which includes barristers from landmark chambers as well as other kind of activists. So it is not a sort of tin pot action group. They are they mean business, and they have lodged this judicial review, which is due actually to be heard at the back end of this week. So we will have some news on this sooner rather than later. And they are challenging not only the use classes order amendment regulations, but also all of the GPDO changes that came in at about the same time. So that's additional extensions and putting 2 floors on the top of your house and things like that. And they've challenged the whole suite of those amendments on the basis that, so three grounds of challenge. They say, well, those new regulations all required a strategic environmental assessment, and one was not done. I mean, unarguably, one was not done. So if one was needed, it was not done. The government failed to comply with the public sector equality duty. That is a much more nuanced ground of challenge. And if anybody's had to ever look at this, the public sector equality duty is just a duty to have regard to that duty. It's not a duty to do anything. So that's, to my mind, a less compelling ground. And thirdly, a failure to properly consult, which I do think has more legs than the public sector equality duty ground, because actually they didn't do any of that. These amendments were rushed in very, very quickly. And so, look, they may well have a point, the claimants here. But like I said, although it's being heard at the back end of this week, it's got Court of Appeal written all over it. It's not going to stay in the High Court. So I don't think we'll get a final answer anytime soon. But what if the action is successful? What if they're right? What if these regulations were not properly done? And the first thing to say is none of their grounds of challenge are about the substance, nor would they normally be in judicial review, but they're not about the substance. So they don't stop the government doing the same thing again, but doing it right. So for example, if the strategic environmental assessment point succeeded and the whole regulations fell away because of that, obviously the government knows what it has to do to fix that. It goes away, it does an SEA, it comes back, makes the regs again. And we're back to where we were. And any local authority taking enforcement action or anything like that in that downtime would be on very shaky territory, I'd suggest. So it's something to consider though, because it might be obviously that if something else occurs, it succeeds, for example, on the failure to properly consult, they do in fact properly consult, or for example, they do in fact do the strategic environmental assessment, and that tells you that you ought not to be doing these changes, then we've got bigger problems, haven't we, for clients that have already taken advantage of Class E. So what happens to clients when they take advantage of their Class E rights now, but in 4 weeks' time, there's no Class E anymore because the regulations have been quashed? What now? Well, so I've been advising my clients really to get a lawful development certificate, to get something from the council, get the council on board to say that this is lawful, because it will then make any enforcement action really shaky and hopefully very unlikely. But obviously it's not going to be, I mean, you've got a really good argument, haven't you, on expediency if a planning authority is enforcing against your client for making a change that that was lawful at the time they made it, even if it's no longer the case. So I think ultimately it's get an LDC, but advice for clients has come up also as to kind of, well, should I be entering into, or should I be purchasing property or entering into leases that are defined by Class E, or are only okay if they benefit from Class E? And the answer is, well, that is a risk. If you've got a lease that is going to be drawn up that refers to Class E and not the previous use classes, then changes are always possible. Okay, so I am a little bit pushed for time, so this is going to be very much a canter, but I think that this is probably the less interesting portion of the webinar. So I've got 3 cases. They are chosen really to try and give a bit of something for everybody, depending on people's practices, because I know that the network, people's practices are very diverse. So first off, for somebody, probably for the housing lawyers, housing planners, people that are dealing with out-of-date policies, comes up a lot, where you've got edge of settlement housing schemes, and you want to say the settlement boundaries are out of date, is the common way it comes up for me. So Peel Investments, here we go again, another paragraph 11 case, and the Court of Appeal was asked to consider this again. And yes, again, we were told that whether a policy becomes out of date, and if so, with what consequences, they are both matters of judgment. They are not dependent on issues of legal interpretation. So the claimants here, it's a claim run by Peel Investments, and they were trying to argue that a plan was automatically out of date when it was time expired. I mean, this is one of those cases that I don't quite see why they were challenging on that basis, because I thought it was pretty settled under the previous NPPF, and not very much has changed since then in terms of out of date, but never mind. They were trying to argue that a time expiry of a plan rendered it automatically out of date, and the Court of Appeal said, as they have done before in relation to the previous NPPF, oh no, it doesn't. The out of date, what out of date does mean is it means overtaken by events, and those events can either be policy events or they can be events on the ground. So I've got a large distribution use type inquiry coming up soon. Out of date can mean, look, you know, your employment land assessment underpinning your extant local plan is incredibly out of date. This happens a lot with B8 type uses because that market and our online shopping has just absolutely exploded. And if you've got a slightly older plan, then it was based on a distribution and employment floor space market, which is very different these days. So those kind of arguments are good. Your plan was supposed to expire in 2014, bad argument. So that's that. The other point from Peel is that there's another reference to environmental policies in particular being designed for a longer lifespan than the plan. So this was very similar to the Hopkins-Holmes decision from the Supreme Court about those policies being a bit different, that greenbelt landscape, those kind of policies, very unlikely to be out of date because they are designed to protect aims that are over a longer time horizon than accommodating a particular housing need, for example. Finny and the Welsh ministers is the second one. We covered this obliquely already when I was talking about the difference between the operative part of a planning permission, the description of development, and the restrictive part of the planning permission, the conditions. And what the Court of Appeal did in Finny was say that those two parts of the permission are separate and different. And when you make a Section 73 application, you're only getting at the latter. You're only getting at conditions. You cannot affect the description. So what happened in Finny was the description of development gave a particular hub height for a turbine, and the condition reinforced that height as being the tallest permitted. The applicant sought to amend the condition, which would have permitted a greater hub height, and the Court of Appeal said, you can't do that, because what you'd end up with, if that application were to succeed, would be a permission that didn't make sense on its face. You'd end up with a description of development saying, hub height 50 meters, and you'd end up with a condition that said no restriction on hub height, or hub height 100 meters, or something totally different. And that we cannot allow. Section 73 doesn't allow you to put a line through the height requirement in the description of development. So if you've got use classes mentioned in your description and you want to change them in the condition, there's a potential for conflict there that you need to be aware of. Sam Smith's Old Brewery, it is a Greenbelt case, and it's about openness and visual impact and judicial review and what's a material consideration, what's not. The important takeaway here for me was that, was twofold. Firstly, visual impact wasn't taken into account in the Greenbelt openness assessment by the officer. That was said not to be an error of law. but partly on the facts. Nevertheless, not a legal error to omit that. So although we do agree, although the Supreme Court did agree, that there was both a spatial and a visual element to openness, you wouldn't necessarily be going wrong in law if you only took one of those into account, because it depends on the facts, what's affected or what's not. And this was minerals development, which didn't have a particularly great visual impact. But openness was said to be a very broad concept, matter of judgment, not law, all of that. And also the court gave some helpful guidance for lawyers, which I don't need to go into too much, but suffice it to say, it makes challenging planning permissions on failure to take into account a material consideration that bit harder. I think that's probably the only takeaway that you need in your practice areas. So I hope that's useful. And those are the three cases I wanted to draw to your attention. I think I've gone a minute over, so I apologise to Deirdre. But thank you very much for your time. And if you've got any questions, do spring them on me now.
Thank you so much, Stephanie. I'm learning how difficult it is to read the questions and listen to you at the same time. So I'll probably refresh my mind afterwards. We've got some questions coming in about Class E. Now, you referred to town centre uses, but we know that in fact the Class E affects those uses wherever they are located, which seems to be maybe a bit of a blip in the drafting. Where there are what is usually called in local plans employment sites, which are allocated for B1, 2, 3, B1, 2 and 8, if they include an element of B1A, can those benefit from the Class E changes now? Is there anything?
I've got a classic lawyer's answer for you, which is, I think it's probably quite fact specific. So it depends what you mean by element. I mean, if you have, so those kind of employment type permissions come in a variety of sizes, don't they? If you have a big employment site, you can get a very flexible permission that says, you know, permission for B1/B2/B8, and you have a flexible use. I think that if you were so you might be able to take advantage of Article 7, for example, if you fell within that. So if you were, sorry, excuse me, rustling of papers, but if you were, you know, building or land being used for one of those purposes, so you were genuinely within B1C before, you could make a good case for saying that you had access to Class E for, you know, for example, if you've got 5 buildings on your employment site, if one of them's a B1C use, then you could argue that you fell within that. There's no sort of concept of necessarily of planning units here. You might have a fight on your hands with the council because they will say, oh, hang on, you know, this is granted by permission, but that's if you've got quite a flexible use and you've chosen to implement it in a certain way. The other type of employment permissions that I see are quite restrictive. So if you've got a shop, you know, some of the really big B8, B2 sites have little cafes in them for the workers. Those are tend, if the planning authority has been on the ball, to be quite strictly controlled by condition. So I've done a couple of recent big employment sites that have ancillary A type uses with them, very tightly controlled by condition, to say they have to remain ancillary to the B2 use, for example. Those types of conditions, it very much depends on their wording as to whether they would continue to bite so that you couldn't access Class E, or whether, if they're sloppily worded and they don't amount to a proper restriction or an exclusion of the use classes order, then you could get into that. But it's going to be so permission specific.
Okay, well, not unexpected, but it is obviously something which is going to occur all over the country. Sorry, I apologize for not referencing everybody's name, but ask a question. I'll just put the questions. You referred to the fact of things that are already in the pipeline were submitted before.
Yes.
Were you leading up to the conclusion that it's best just to withdraw those so that one could just assume the Class E flexibility now that we're past the start date?
No, probably not. I mean, I think it depends, doesn't it, as to whether you think if you've got it in and you've done all the hard work, I don't see the benefit in withdrawing it because you've then banked something, haven't you? I suppose the benefit of withdrawing it would be if you thought you were going to get some conditions that you didn't want.
Yeah.
And the planning authority was going to give you some conditions you didn't want. And they were going to use the full planning permission to do that. The flip side of that is, well, there is a real risk that the use classes order amendments will fall in this judicial review. And that is an uncertainty that you can deal with by getting your full planning permission in place now. And then it's unarguable, isn't it? It's going to be, yeah, but I think if you're threatened by conditions you don't want, you might want to opt out and bank Class E, but I think there's still merit in a full planning permission, to be honest.
Okay, thank you. Dotting around here, one of the things which got reported on our network today and yesterday was because of the breadth of Class E, when planning applications are submitted for that flexible use, authorities are sometimes requesting matters such as sequential tests because A1 is within there, or there's a confusion as to whether SIL applies because it might not apply to all the range of uses in Class E. Have you got a view on what would be a reasonable, what's the rebuttal to a local authority being unreasonable in its requirements?
Well, I think this is probably one of your, if you've applied for full planning permission, you've put yourself into that regime, haven't you? So that's one of the downsides of pursuing a full planning application, that you've then put yourself into the policy tests for sequential assessments. If there's a loss of retail, or if you're putting retail somewhere out of centre, you're putting yourself into those policy thresholds. Ditto SIL. If you're relying on Class E, obviously that's not, it's not development. So you're not opening yourself up to those things. I think in terms of SIL and whether some developments liable or not, that's going to depend, isn't it, on terms of what you actually build, and what you implement, and whether there's a development and a permission that can bite on or not. And if you rely on Class E, well, there isn't. And if you have a qualifying planning permission, then there is. I think sequential tests are obviously harder because if you're trying to benefit from, if you just say, well, I want a Class E unit, please, and I want it out of town, then I think probably they do. It's a bit like EIA or whatever. They've got to, haven't they, assess the sort of realistic worst case, because otherwise they haven't assessed the impacts of the development that you're proposing. So I don't think that you can always actually say, oh, I'm not going to give you that, because that's the case. But but the rebuttal is, look, the government has said that if I apply for a planning permission for a creche, for example, you don't need to require anything for me then to change from there to retail. So I don't think you should be requiring it now, because actually if I just built my creche and then transferred to a retail unit, there's nothing you could do about it. So that's my fallback. The problem is you'll be met with a suggestion that says, okay, well, I'm going to condition you then. If you say you're building a creche, you'll build a creche.
Yes. Okay. I've got a question here what about permissions for A1 with a condition stating something like shall not be used for any other use other than A1, including those allowed under the GGPO?
Yeah,
This,
that's a classic, isn't it?
that is the circumstance you were talking about, which would say you can't wiggle past that with Class E.
Yeah.
Okay. Right.
Yeah, I think obviously so there's a whole raft of case law I won't bore you with about the type of wording you need in those types of conditions to be effective at excluding the use classes order. And obviously there's loads of stuff if you were going to get a new planning application, new planning permission to impose those kinds of conditions, you know, that you have to meet certain tests. It's not easy necessarily for the planning authority to impose those conditions that take away rights. But if you've got an extant consent that says this is an A1 unit, it will only be used as an A1 unit, and notwithstanding anything it says in the use classes order or the GPDO, you'll be staying as an A1 retail unit. Those kinds of conditions, if properly worded, remain effective. You know, the fact that A1 is a concept that no longer necessarily exists, I don't think is going to help you. Interpreting that condition, it will help the planning authority if those conditions say, which they should do if they've been properly drafted, you know, the use classes order and any you know, reenactments or consequential regulations, to make sure that it captures this reincarnation of the use classes order. So again, it sort of comes down to wording, but if it was effective before, it's very likely to be effective now, unless there's something in the drafting you can pin it on.
Okay. I'm just going to finish with there's two questions that have come in specifically about planning policy impacts as to whether if planning policies are couched in the former terms, can they be said to be out of date where that doesn't encompass the flexibilities of the new Class E?
I think you've got a runner there, haven't you? You could argue that that's no longer the case. I think it's going to depend on the evidence base and why. But obviously the government, you've got to take the use classes order and the flexibility now that allows you into account when interpreting, you know, when reaching a view as to whether that policy is out of date. And it may be that there remain very good reasons for having that policy. So central London, for example, I know Westminster has incredibly restrictive policies as to shop frontages. So they require 3 in a row, and if you have a break, then you can't have it. And they've got very protected frontages. So those kind of active frontage policies probably have more to them. Whereas, you know, a generic kind of, oh, we just want shops in the town centre policy, there's an argument that particularly if in the context of your application you're applying for something that's flexible, there's something to be said, isn't it? I don't think I can go as far at all as to say, oh well, obviously they're all out of date. I don't think that's the case. It's going to depend on, I'm sorry, very lawyer answer again, case by case.
Okay, I think you probably covered the other question I had there, which was about where policies are couched in a percentage of A1 uses or whatever in a town centre. That policy obviously is going to have some difficulty in terms of the flexibilities. Does that carry the same weight as a restrictive condition?
Well, I mean, you only get into the policy world, don't you, if you've made an application that the council can sort of bite on, and then so obviously it's not an absolute blanket ban like a condition is. It's more nuanced than that, and obviously there are various things that have got to be balanced when you've got a full planning application. But the fact that policy has arguably been superseded by this strong drive to encourage town centre flexibility is a factor they must take into account.
Okay, I'm just going to sneak in one tiny one. If you did make an application before 1st of September on the old use classes,
Yeah.
and they're issuing the decision now, can we expect the decision to be couched in the terms in which we applied for it, or should it in some way reflect Class E?
Well, they shouldn't have changed the description without talking to you. So there's that. I also think they will likely interpret the requirement to determine with regard to previous use classes as a requirement to, when I say they, I mean planning authorities. We'll probably see that as a requirement to just carry over references. So I think you can expect, if you applied for planning permission, say for A1 to A3, that is what your new permission will say, because they should have come back to you, shouldn't they, and said, how about we use Class E for this?
Okay. I'm ever so sorry, everybody. There are other questions, but we've run out of time to put them. But I do appreciate your detailed interest in what we've been looking at today. And Stephanie, I think we're about to be closed down. So yes. Could I just put forward a very heartfelt thank you to you for helping our network and giving us such an excellent presentation based on your own experience. Thank you.
I hope it genuinely was helpful.
It was. Thank you.
Thanks.
Good afternoon, everybody. Over and out, I think. I'm being closed down.